remain standing for the opening prayer by Her Honor, Mrs. Julian Bartlett Allen.
Creator, our eternal Father, we thank you for the 60 years of the court's existence. We stand before you today at this opening of another court term, grateful for your unmerited gift of life. We are mindful of the solemn duties entrusted to us. We seek your guidance and wisdom as we enter into this term. Grant us the clarity to discern truth, the courage to uphold what is right, and the humility to recognize our own limitations. May our decisions be guided not by prejudice, but by the unwavering principles of justice and equity. Inspire us to be instruments of your peace, to protect the innocent, and to give voice to the voiceless, to ensure that the scales of justice are balanced for all. We ask for your blessings upon this court, everyone working within it, and all whose lives will be touched by its proceedings. This is our prayer.
Good morning and welcome to the special sitting of the Industrial Court of Trinidad and Tobago for the opening of the 2025 to 2026 law term. In accordance with Section 7(4) of the Industrial Relations Act, Chapter 8801, the President of the Industrial Court of Trinidad and Tobago considers the Southern Academy of the Performing Arts necessary for this court's special sitting today, September 17, 2025.
Good morning. The Honorable the Chief Justice, Mr. Ivor Archie, ORTT, Chief Justice of the Republic of Trinidad and Tobago, the Honorable Jagdeo Singh, Speaker of the House of Representatives, the Honorable Saddam Hussein, Minister of Legal Affairs and Minister in the Ministry of Agriculture, Land and Fisheries. Senator the Honorable Leroy Batiste, Minister of Labor, Small and Micro Enterprise Development. The Honorable Dr. Michael Dowlat, Minister of Education. The Honorable Ernesto Kizar, Minister in the Ministry of Energy and Energy Industries, the Honorable Clyde Elder, Minister in the Ministry of Public Utilities, Heads of Court, Vice President, Chairman of the Essential Services Division and Judges of the Industrial Court, His Excellency Kerwin Garcia, SC, other members of the Inner Bar and Legal Fraternity, representatives from the International Labour Organization, Decent Work Team, and Office of the Caribbean, heads and representatives of government agencies, employers' organizations, and trade unions, practitioners of industrial relations, distinguished ladies and gentlemen, members of the media, viewing and listening audience, and of course, the students who have joined us and their teachers. Good morning. The Industrial Court in San Fernando was opened on February the 15th, 2005. The first sitting of our court in San Fernando was held the very next day. The then President, His Honor Mr. Addison Khan, now deceased, chaired a two-member panel of which I was the other member. The court heard trade dispute number 154 of 2004 between Banking, Insurance and General Workers Union and Antilles Credit Union Cooperative Society Limited. The union was represented by Mr. Don Devnish, then Assistant General Secretary, and the credit union was represented by attorneys at law, Mrs. Norma Maynard Marshall, and Mr. Dinesh Rambali. Mr. Rambali served as a judge of this court sometime after. The judgment in the Antilles Credit Union case was delivered by me on June 7, 2005. I am pleased that not only did I sit on the first matter heard in San Fernando, but the duty now falls to me to preside over the court's first special sitting in San Fernando, in this our 60th year of existence. As the court celebrates its Diamond Jubilee, I reflected on the qualities of diamonds. Among the many notable qualities of diamonds is their hard nature. Diamonds are the hardest material known to man, which makes them invaluable and useful for jewelry, but even more so in industry. Diamonds also have a high heat conductivity, and for this quality, they are used in a number of industries, including the automobile and computer industries. Old school music enthusiasts would also appreciate the diamond needle as a standard component of superior music players. Like diamonds, the industrial court over these 60 years has shown its endurance. The court and its judges have been able to withstand pressure and to absorb heat, all in the interest of making better provision for the stabilization, improvement, and promotion of good industrial relations. Over these past 60 years, the court has had 7 presidents, 11 vice presidents, and 6 chairmen of the Essential Services Division, and over 50 judges. 13 registrars have headed the staff of the court. All of the members of the bench and every member of staff have contributed to the court's endurance and its success over these past 60 years. The court owes them all a debt of gratitude. I now turn to appointments to the court. I address this because from time to time, appointments to the court, including this year, have attracted much public attention and discussion. Firstly, let me welcome to the bench 3 judges who recently joined the court. Their honors, Dr. Selwyn Samaru, who returns to the court having served before, Mr. Brahmanan Dubey, and Mr. Rudranath Indar-Singh. Their honors, Samaru and Indar-Singh, have been appointed to the Essential Services Division, and His Honor Dubey to the General Services Division. We welcome them to the bench and feel certain that they will each contribute significantly to our jurisprudence. The Industrial Court consists of a president, a vice president, a chairman of the Essential Services Division, and judges referred to as members in the Industrial Relations Act, Chapter 8801. When the Industrial Court was established by the Industrial Stabilization Act, Number 8 of 1962, the ISA, the president of the court was required to be a judge of the Supreme Court of Judicature, designated by the Chief Justice after consultation with the Prime Minister. Provision was also made for 4 other members appointed by the Governor General for such period and on such terms and conditions as he thought fit. 1 member, a barrister or solicitor of at least 10 years standing, was the vice president of the court. The other 3 members were comprised of 1 duly qualified accountant, 1 qualified economist, 1 member who was either a duly qualified accountant, a duly qualified economist, or a person experienced in industrial relations. You would appreciate, therefore, that it was possible for the court to be without a member experienced in industrial relations. And you may wonder why the emphasis on accountants and economists. At that time, the jurisdiction of the court extended to the hearing and determination of complaints relating to the price of goods and commodities. Appointments to the court are now made in accordance with Section 4 of the IRA, the Industrial Relations Act. The IRA repealed and replaced the ISA on July 31st, 1972. The court now consists of two divisions, the General Services Division and the Essential Services Division. Each division has a chairman and a minimum of 2 other members, as may be appointed by the President of Trinidad and Tobago. In every instrument of appointment, the President shall indicate to which division the appointment is being made. The President of the court shall be a judge of the Supreme Court of Judicature designated with his consent by the President of Trinidad and Tobago after consultation with the Chief Justice, or a person who has the qualification, age accepted, to be appointed a judge of the Supreme Court of Judicature and is appointed by the President of Trinidad and Tobago after consultation with the Chief Justice. The Vice President of the court shall be an attorney at law of not less than 10 years standing, appointed by the President of the Trinidad and Tobago. The other judges of the court, including the chairman of the Essential Services Division, are appointed by the President of Trinidad and Tobago from among persons experienced in industrial relations or qualified as economists or accountants, or who are attorneys at law of not less than 5 years standing. Members of the court appointed to the General Services Division exercise the jurisdiction of the court with respect to services other than essential services, and those appointed to the Essential Services Division exercise the jurisdiction of the court as set out in Section 7 of the IRA in respect of essential services. The essential services which are set out in the second schedule of the IRA include electricity, water, sewage, telephone, and civil aviation. The special tribunal established by the Civil Service Act and referred to in the Police Service Act, the Fire Service Act, the Prison Service Act, and the Education Act, as well as the Supplemental Police Act and the Central Bank Act, consists of a chairman of the Essential Services Division and 2 other members of that division selected by him. That's a special tribunal. The tribunal hears and determines disputes arising under the acts just mentioned, as if those disputes arose in essential services. In the hearing and determination of any dispute referred to it, the special tribunal may, in addition to taking into account any submissions, arguments, and evidence presented or tendered by or on behalf of the appropriate recognized association and the chief personnel officer, in its judgment, shall be guided by the considerations set out in Section 22A to F of the IRA. Those considerations are, and I quote, the necessity to maintain and expand the level of employment, the necessity to ensure to workers a fair share of increases in productivity in enterprises, the necessity for the establishment and maintenance of reasonable differentials in rewards between different categories of skills, the necessity to maintain and improve the standard of living of workers, the necessity to preserve and promote the competitive position of products of Trinidad and Tobago in the domestic market as well as in the overseas markets, and finally, the need to ensure the continued ability of the government of Trinidad and Tobago to finance development programs in the public sector. It is noteworthy that the matters outlined at section 22A to F above are matters that the General Services Division may take into consideration in disputes in which the Attorney General intervenes and in which he makes submissions. However, the Special Tribunal, in addition to submissions and evidence and arguments of the parties, in its judgment, shall be guided by those considerations in the hearing and determination of all matters. I return to the appointments now. Except in the case of a judge of the Supreme Court who has been designated a president of the court, all offices in the court, including that of president, are made for a period of 3 to 5 years, subject to reappointment. Removal of a judge during the period of appointment is provided for under Section 4.8 of the IRA. In accordance with that subsection, a member of the court, other than a judge, who has been designated as president under Section 4.3A1, may be removed from office during his term of office only for inability to perform the functions of his office, whether arising from infirmity of mind or body or any other cause, or for misbehavior, but shall not be removed except in accordance with Section 106 of the Constitution, Chapter 101. With respect to tenure of judges, the absence of tenure for judges of the court, which has also gained attention from time to time, poses a number of difficulties for the smooth running of the court, not unlike that faced by any other organization which suffers involuntary turnover of its personnel. The impact on the court includes loss of skill and institutional knowledge, difficulty in sustaining a culture of teamwork, morale, and a sense of uncertainty among judges. The lack of tenure also affects the perception of the independence of the court. The closest that the court has come to realizing tenure for its judges was in the Constitution Amendment Bill 2015. The bill was introduced and read for the first time in the House of Representatives by the Honorable Errol MacLeod, then Minister of Labor and Small and Micro Enterprise Development. The bill went to a second reading but lapsed thereafter. At that time, the Industrial Relations Amendment Bill 2015, which was to be read in conjunction with the Constitutional Amendment Bill, was also introduced. Perhaps the time has come for the question of tenure to be seriously revisited. In addition, it is my view that qualifications and/or experience in occupational safety and health should be added to the existing disciplines now required for appointment to the court. Sometime in the future, the need may well arise for the court to have a division of occupational safety and health relevant to matter also. Relevant to matters brought to the court under the Occupational Safety and Health Act, Chapter 8801, is the limitation period for complaints under the Act. In a judgment of the Judicial Committee of the Privy Council handed down yesterday, the board ruled that the limitation period for complaints brought for health and safety offenses before the industrial court is 6 months, and the civil proceedings pursuant to Section 83A, that is, by an aggrieved person, must be brought within 2 years. The court has eagerly anticipated this judgment to provide certainty, and since hundreds, by our count, somewhere between over 200 and certainly close to 400 matters were stayed pending this decision. While I have only read the judgment and have not had the opportunity to thoroughly digest it, a few paragraphs caught my attention, namely paragraphs 47, 49, and 50. From my cursory reading of those paragraphs, I wish to highlight 3 points from the dicta regarding enact. Firstly, Section 83A, and these are the words of the Privy Council, I now quote, creates a potential route to making a criminal complaint outside of the 6-month time limit, close quote. The board also said that an aggrieved person, which is not defined in the OSH Act, must extend to cover employees, trade unions, and others affected by a contravention of or a failure to comply with the Act. And thirdly, there is no reason why the OSH authority or an inspector in the authority cannot be an aggrieved person. Perhaps when others, including the Minister of Labor, they have the opportunity to read and digest that judgment, some consideration may be given to whether there is need for an amendment. And certainly the 6-month period, if the authority is properly staffed and so, they may be able to meet it, but those are administrative considerations that those with the competent authority, they may wish to look into. I just say that from my cursory reading of the Act. The work of the court, I now turn to the work of the court in the 2024-2025 period. Activities in commemoration of the court's Diamond Jubilee. This is the first aspect I'll deal with. The court had hoped to embark on a number of initiatives for this, our 60th year, including our annual stakeholder conference and a quiz on the court for students. However, financial constraints have affected some of our plans, including those 2 initiatives. Therefore, we are happy that we could invite students today, and we thank you, the students, and your principals and teachers for accepting our invitation. And of course, we already recognize the Honorable Minister of Education. Many of our guests today were present at our service of divine worship on March 20th at the parish of the Assumption, Maraval, which marked the start of our Diamond Jubilee. Further activities included stakeholder outreach. Their honors Daniel and Austin made a presentation on the jurisdiction, processes, and traditions of the court to the Hewarding Law School in March. The honors George Marcel and Mitchell reflected on the 6 years of the court in a presentation entitled Celebrating the Court's Role and Legacy, close quotes, and this was done at the Caribbean World of Work Forum 2025, presented by the Cipriani College of Labor and Cooperative Studies. Their efforts at both presentations were ably supported by our communications and library staff, who made brochures on the court available. Some of those brochures are available today in the display by the library in the lobby, and we hope that you will find the time to stop by and see what the library has put out. Features on the work of the court were produced by the Information Division of the Office of the Prime Minister. These features included past and present members of the court, as well as some of our stakeholders. We thank you all for your input. Many of the features were aired on radio and television and are accessible on our Facebook page, YouTube channel, and now our recently introduced Instagram page. We hope to culminate the year with an awards function for judges and staff to show the court's appreciation for their service over the years. Very high on the list of our priorities for the Diamond Jubilee year is the publication of the 2nd volume of the court's law reports, which has been stalled since 2014, mainly because of a lack of funding. We are optimistic that in the 2025-2026 budgetary allocations, the court will get the necessary funding to produce our second volume and move on to our third. With respect to institutional strengthening, the court participated in ILO's sub-regional symposium on dispute resolution in the Caribbean, making labor justice accessible to all, which was held on the 9th to the 10th of October 2024 in Port of Spain. It was convened by the ILO, Decent Work Team, and Office for the Caribbean, Port of Spain. The main objective of the symposium was to provide a forum for dialogue and exchange of experiences between participants from dispute resolution institutions with the aim of improving the performance of labor dispute prevention and resolution systems in the Caribbean. At the end of the symposium, participants formulated conclusions which, among other things, reaffirmed the ILO's and the Caribbean countries' commitment to advancing social justice and promoting decent work, and underscored the importance of harmonious industrial relations in fostering economic growth and sustainable development. Following the symposium on October 11th and 14th, 2024, the ILO facilitated the rollout of its tool for the self-assessment of the effectiveness of the adjudicative mechanism for labor disputes resolution at the Industrial Court. ILO's facilitators were Mr. Pablo Arellano, Regional Specialist for Latin America and the Caribbean in Labor Relations and Social Dialogue, and Ms. Nancy Varela, Social Dialogue and Labor Administration Specialist, ILO Decent Work Team, and the Office of the Caribbean. I headed the team of participants from the court, which included judges, the registrar, and key personnel, including the court administrator. The tool provided for the measurement of key indicators, including efficiency, speediness, accountability, accessibility, independence, impartiality, fairness, equality, professionalism, and enforcement. It provides the court with very useful indicators to measure and strengthen its effectiveness. The court thanks the director of the ILO, Decent Work Team, and Office of the Caribbean, Dr. Musa Bayana, and the entire hard-working team for their commitment to improving the performance of labor dispute prevention and resolution systems in the Caribbean, and for their continued support in the area of training. I now move on to team culture building training in the court, which was also undertaken as a part of strengthening our internal systems. In April, judges participated in a team culture building workshop. The workshop utilized the DISC personality test behavior-focused assessment approach that characterized participants into 4 primary styles: dominance, influence, steadiness, and conscientiousness. By providing insights into the natural behavioral tendencies and priorities of the various DISC styles, the workshop aimed at improving communication and collaboration among judges by explaining how colleagues with the various mindsets and styles approach their work. This type of training is especially important for judges in our court, as traditionally we sit in panels of 3, and understanding our mindsets is invaluable in building an effective team and in the way we interact when we have to discuss our judgments and so on. The sessions were insightful, helping us gain a deeper understanding of our collective team dynamics. The workshop was held at the Judicial Education Institute of the Judiciary of Trinidad and Tobago Training Center. We record our thanks to facilitator Ms. Antonia Lucky and the Judiciary, and in particular the JEITT, for making their training facilities available for our session. I turn now to statistics for the year in review. During the year in review, 771 new cases were filed. This represented 32 less cases than in the 2023-2024 period. That period recorded 803 cases. During the said period, that is the period under review, 1,114 matters were listed for hearing, some of which were consolidated and or heard together, resulting in 1,030 actual hearings. The court disposed of 854 matters during the period, an increase of 75 more than the 779 matters disposed of for the same period in 2023-2024. During the period 2024-2025, the clearance rate was 110.77%, which is 13.76 percentage points higher than the period before 2023-2024, when the clearance rate was 97.01. Of the 854 dispositions, 255 judgments were delivered, 262 matters were settled through the conciliation and bilateral process, and 238 cases were withdrawn. 99 matters were dismissed for a number of reasons, including non-appearance by the union or by both parties, that they concerned workers who were not members in good standing of the union, which brought the dispute, and also for opinions of the RRCB, that is the Recognition, Registration, and Certification Board, that the aggrieved was subject to the exclusion under Section 2(3)(e). That is to say, they were not deemed a worker under the Act. The court referred 513 matters to conciliation during the review period upon the request of parties. 60 were settled in conciliation and bilaterally, 17 were withdrawn, 213 returned to open court, and 223 remain in conciliation. The court conciliatory process continues to be well utilized. Of the total number of disputes filed at the court, both in the general and essential services divisions, trade disputes remain the largest number of matters filed. 610 trade disputes were filed, followed by 45 complaints under the Occupational Safety and Act, 40 matters under the Retrenchment and Severance Benefits Act, and 27 industrial relations offenses were filed. I am heartened by the increase in the clearance rate in spite of our challenges of shortages of court reporters and secretarial staff. Of a total of 25 posts of Verbatim Reporter 1 and Verbatim Reporter 2 on the establishment, all are vacant. That is, there is no permanent staff filling those positions. These are positions which are filled by the Public Service Commission. In order to partially fill that gap, the court has utilized a combination of 10 acting verbatim reporters / service providers, many of whom work on a part-time basis and are drawn from the retired verbatim reporters. So to clarify that, there are 25 posts of verbatim reporter, both 1 and 2, combined on the court's establishment. But there is no permanent appointment to any of those positions. And in order to treat with the matter, the court has engaged a strategy. I think there may be 1 or 2 acting verbatim reporters, and then there are some service providers. They are drawn mainly from retired, many of them from our retired verbatim reporters. The CAT reporters I did not include because we are fine with CAT reporters. We have 10 positions and 9 are filled. So the CAT reporting aspect of the court's work is reasonably satisfactory. Of course, we always aim for 100%, but in terms of verbatim reporters, we are lacking there, and it does affect the production of notes and transcripts. We also have, moving on now to our support for our judges and at the court, we have 2 legal officers. Among many of the duties, they assist judges in their research. While we work to improve the staff complement, the judges and the staff continue to give of their best. We continue to strive to fulfill our mandate of hearing and determining matters expeditiously, even with the gaps in our staffing complement. We commend our staff for their efforts. However, there is an impact on our delivery of more timely judgment, and we resolve to further improve our delivery in this court year. Our Tobago sittings. The court continued sittings in Tobago this year, which we resumed last year. The court sat from August 11th to August 15th to 20th this year at the Supreme Court in Tobago. The court held 7 hearings, 3 conciliation sessions, and 1 case management conference, which we refer to as mentioned in the report in our court. The court was led by the Vice President, His Honor Mr. Sovereign, then acting President, and their Honors Morton Mitchell and Gillian Bartlett Allen, and ably supported by staff. 7 oral judgments were delivered, 1 matter was settled by conciliation, and 2 other matters were dealt with in conciliation were adjourned to new dates of hearing, along with the matter addressed in mention and report. 7 oral judgments were in respect of 10 disputes, and it concerned 25 workers. So in that 1 week, the court was able to treat with the matters in respect of 25 workers, and in the 10 disputes, those matters were all disposed of, and there was no need to have the workers travel to Trinidad and Tobago. That particular our Tobago sittings are in keeping with our thrust for greater access to justice by all. And one of those sittings in Tobago, one of the hearings, was a hybrid sitting. Both representatives were unable to secure transportation to Tobago during that week, which coincided with the Great Race. And we all know that a lot of Trinidadians flocked to Tobago during that period. As a consequence, both representatives agreed to hold a hybrid hearing. They were present at the court in Trinidad, while the workers and employers witness, as well as the judges, were at the court in Tobago. From all accounts, the matter proceeded smoothly and ended in the parties agreeing to a settlement. The sessions in Tobago were facilitated by the judiciary's willingness to share its facilities with the industrial court yet again. On behalf of the court, I would like to express my gratitude to the Honorable the Chief Justice, Mr. Ivo Archie, ORTT, for once again generously extending to the industrial court the judiciary's court facilities in Tobago. We also wish to thank the staff of the judiciary for their invaluable support during that period. The court also extends its gratitude to the attorneys at law and union representatives and industrial relations consultants who sacrificed part of their court vacation to facilitate those hearings. We commend our judges who also gave up their time during their vacation, and members of staff who worked tirelessly, selflessly, and efficiently to ensure the smooth working of our Tobago sessions. The court continues to work on making the Tobago Industrial Court a reality. We look forward to the day when we will have our own court in Tobago, which will facilitate year-round hearings. Information technology. The project on the conversion of the old Judicial Enforcement Management System, GEMS, database to the new case management software has continued. The developer is working non-stop to assiduously complete this project to provide the court with a robust system and offer e-court services to all litigants. We plan to engage our stakeholders at the appropriate time on our proposed e-court services. However, the court is mindful of the persons whom we serve, and our aim is to enhance our functioning to make access easier and more in alignment with the digital age, while keeping the needs of our stakeholders, both internal and external, uppermost. The court is also using technology to modernize its warehouse facility for the storage of its old court records. Our new warehouse facilities have been outfitted with shelving, which utilizes a radio frequency identification (RFID) feature. The RFID feature allows for wireless tracking and identification of documents. It is an efficient way to identify individual items electronically, leading to enhanced security and faster retrieval of documents. The court's warehouse is now equipped with smart shelving, which combines sensors, digital shelf labels, digital signages, RFID technology, cameras, and a management system, leading to greater overall efficiency in managing our old records. It is expected that it will be fully operational by the end of 2025. Repair and upgrade of our court in Port of Spain, which is long overdue, remains a challenge, and this is under improvement works now. We remain hopeful that in the new financial year, we will receive sufficient funding to start some much-needed work to upgrade our court. The staff and occasionally our judges are not as comfortable as they should be. I sat in awe yesterday, listening to what seemed to me to be the many ongoing projects of the judiciary for improvement in its physical facilities. While relatively speaking, we are a small court, we do have similar needs, and now we have outgrown our space. We have been our brother's keeper in relation to housing the Recognition, Registration, and Certification Board on the court's third floor for a number of years. We now need that space urgently. It is our hope that in this court year, suitable premises will be found for the board. And I see the Minister of Labor here. I'm sure he would take note of this. And in conclusion now, because we have our students, we can't keep them all that much longer. In conclusion, as the court moves into its 61st year, we will continue to fulfill our mandate of dispensing social justice and providing for the stabilization, improvement, and promotion of good industrial relations. As I said at our last sitting, it is a testament to the court collectively, its judges, past and present, staff, and stakeholders, that the court has withstood the test of time. I thank you all, those who have attended this, our first sitting in San Fernando, in person, and those who have joined us online, listened on the radio, or followed the television broadcast on TTT. We thank the Information Division of the Office of the Prime Minister for their assistance in productions which record the work of the court over the last 60 years. The court is particularly pleased that at this, our first opening in San Fernando, we have students attend, which is also a first time for the court. I thank the media for their coverage of this event. and for the infomercials that have been aired in the lead up to this sitting. Special thanks to the tireless efforts of those members of staff who have made yet another special sitting a success. I know it was no easy task. I also thank the Ministry of Agriculture for assisting us with our flora. The court now stands adjourned to 9 a.m. tomorrow at Port of Spain and 9:30 a.m. in San Fernando.
All rise.
This is TTT. Live for local.
You really playing